when all righty. That tells me what I need to know. There you go. This issue may come up frequently when we're doing staffing. So don't forget, sometimes you may have to stop and say, is the issue we're talking about, is that something that we're required to report under those mandated reporter statutes? And then a court order can allow us to talk about information, and we'll talk about what that looks like in just a moment, and crimes on premises. But absent any of those exceptions, we cannot talk to anybody, and with we being treatment cannot talk to you legal folks without a consent. So let's think about what that looks like when we're sitting and staffing. If your staffing is like most of our staffings across the country, we have people come and go, and we have people that we add into staffing. And so this becomes really important when you got people coming and going to remember that you cannot, and treatment cannot release information unless that person who's attending staffing is on the consent. And what that essentially says is we have a prohibition against redisclosure. So if treatment has permission to talk to us on the team, that core team membership, and we're going to talk about this later, and then somebody drops in from your child and family services division in your court, to continue to talk about what is going on, even though it's relevant, perhaps, without a proper consent, is redisclosure and prohibited. Now, this regulation applies to us because it applies to treatment, and it's a very broad regulation. If your treatment provider or anybody who's receiving those confidential, that confidential information receives any kind of federal funding, directly or indirectly, assume it applies to your court. So an example of that would be quickly, many states have money that comes through the Supreme Court and then is handed down to treatment courts to pay for treatment. A lot of that money is federal funding, maybe indirectly. And so that would loop in, even that situation would loop treatment into being required to comply with Part 2 of Title 42. So what's the recommendation? Always have your consents and pay attention who's in staffing. So let's go to the next slide, and we're going to talk about consent forms. The consent forms have requirements. So if we don't meet the legal requirements on our consent form, then they're not valid. And so you see these requirements here. I'm not going to read them to you, but we will show you where to get some forms in just a few moments on a later slide. Again, other means of disclosure, we've talked about this, are very limited. Subpoenas must have a court order to go along with them in order to release that information. So you see the basis on a civil subpoena that the parties must show, or in a criminal subpoena, which is a higher standard, in order to get that order to release this confidential information. Now let's talk about HIPAA just a little bit. HIPAA doesn't apply to the courts. And so those of you who pick up a docket sheet or look at HIPAA information that may be been considered in a criminal sentencing, is because HIPAA itself does not apply to the courts, but it applies to our providers. Therefore, it applies to us. HIPAA and Title 42 are similar, but there are some differences in the requirements on the consents. And so, and some differences in when HIPAA applies and when Title 42 applies. So my recommendation is, again, that you look at the sample forms that are provided to you at ndci.org. There are sample forms that we look at as staff to ensure that they continue to comply with confidentiality regulations as they change. One of the examples I have on this is when we had COVID legislation, and the federal government and the HIPAA forms were kind of eased up a bit so that information could be shared more easily due to the fact that we weren't on site in many situations. So it's important to keep up to date on those. So I would encourage you to look at those. You can have one form that contains the requirements of each of these provisions. So here's your sample forms. The drug court judicial bench book, if you have a hard copy, hang onto it because most of this information is now available online. One of the things that I want to point out on this slide is that in HIPAA, you can have a court order authorizing the release of information. So in the judicial bench book, you will find a recommendation that the court sign an administrative order for each participant coming into the program, authorizing the release of the information. And then that's just an additional layer of protection for each of us. And that form is contained in the bench book. So you have that resource available to you. So all of us love talking about confidentiality and excuse me, and we're excited that we get to move on now to something that is near and dear to most of our hearts, and that's a little more of the case law. But we know confidentiality protections are at the heart and foundation of what we do. Now let's move on from the forms and let's talk a little bit about some of the other issues that arise with confidentiality. And what about open courtrooms? This is a case that's been around since 2002. So most of us have seen Florida versus Noel Bush. We know that drug court is in open court when we are doing those status hearings. But that lends itself to some problems, doesn't it? Because we want to be careful about the information that we talk about in open court. Courtroom is theater. That's one reason courts work. But whenever we as the judge or legal people are talking about participants' progress in treatment, we need to understand that we are talking about essentially confidential information. And so we must tailor our conversations so that we are not inadvertently releasing that information. But this case does tell us that it's important to have open court, status hearings that are open, courtroom as theater is appropriate, and we can proceed along that line. So here's your kind of recommendations in open court. Don't discuss protected health information. We don't need to know everything even in staffing, but sometimes we do become privy to some pretty sensitive health information. And we need to think about those of us who are then leaving staffing and talking to people in court about how that message is framed. So be very, very cautious about sensitive matters. One of the examples I can think of is whenever we have domestic violence issues. And there are a host of ways to deal with this, maybe being a little cryptic, holding the participant until later to talk about those sensitive matters, maybe at the end of the docket, so that everybody's left the courtroom and you have time to talk just to that participant. And then use this judicial bench card, again, which is available online. And what this bench card does is give us as judges kind of some ideas. So the bench card flips up and it's got little tabs and it tells you on the tab, what kind of topic you're talking about, and then it gives you some suggested questions. So that's helpful. And I love this bullet point. This is kind of my heart, if you will. I learned this after I retired at the level I probably should have known it earlier, and that is motivational interviewing. Now, all of us who have been in judicial training with National Judicial College or any of those kinds of trainings have talked about motivational interviewing and, that open-ended question. But this is a technique. And so I want to encourage you to go to SAMHSA. I think it's tip 36. You can look at SAMHSA, and it talks about motivational interviewing within the scope of being a technique and explains to us as judges why it's important and how we can use this tool to actually help people move through the stages of change. So I would encourage you to look at some of the research and some of the more in-depth articles on motivational interviewing. But the core of this is the participant talks. We listen, and we listen for particular things. So we're not talking about sensitive information, but we're letting the participant talk, and we're guiding that conversation to help that participant understand that change is possible and that it's desirable for the participant, him or herself. And then use that courtroom as classroom. You can move away from using somebody particularly and talk about things in general. We don't want to be shaming. So sometimes it may be important when somebody sits back down in status hearings that we may talk about a concept, but it's not pointed necessarily at the person while they're standing there. So we're not shaming in any of our kind of interactions with folks. So let's talk about staffing. Now, staffing can be closed, and there are 2 Washington cases. You see them at the bottom of the PowerPoint. So you can go to the site. They're really helpful. Washington State has some of the most protected open court regulations and laws in the country. So really concerned about open court proceedings and protecting that open court setting in the state of Washington. And yet even those courts who reviewed the closed staffing said that, you know, drug courts are just different. They're different from ordinary criminal courts. And so therefore staff meetings are not subject to the open courts provision of the state constitution. Now, there's a little bit of caveat, and what the court did was talk about, you know, as lawyers, we engage in pretrial conferences on trial matters. We may have in chambers kind of meetings to talk about motions in limine or some of those other motions leading up to trial, and that's acceptable. So staffing is akin to those kinds of conversations. What the court said was staffing is not a, quote, critical stage of the proceeding. If you find yourself in staffing sliding to a critical stage of the proceeding, it's really important to move that discussion into court. And the best example of this is termination hearings. Whenever we are talking and staffing about a potential termination of a participant from the program, we need to keep in mind that becomes at a point, a critical stage of the proceeding. That's requiring that we have those due process protections. So we may stop that conversation and staffing and set the matter for hearing in court. So judges and lawyers were good at this. You know, I can't give you every possible scenario, but these principles are something to keep in mind so that we ensure we operate within constitutional protections for our participants. Now, we are seeing law enforcement increasingly come on board with treatment courts, and it's really exciting. If you can get law enforcement to staffing, kudos to you, because they add such a important component to the staffing. They build community support. So we're reaching out, bringing in the community. They build participant rapport. We all can tell stories, all of us who've been doing this forever, about participants wanting their arresting officer at their graduation. And so what participants learn is it's not a us, them mentality, but they begin to see law enforcement as a positive influence in our community. And then that, again, when we're talking about breaking that chain of criminality, what we're seeing is kids who are growing up learn to respect law enforcement, and law enforcement learns that our participants have a lot of potential, and they can become law-abiding people and productive members of our community. And so it works both ways. They also give us valuable information. And so you all who have been prosecutors, as I have, or defense attorneys, you know, you learn to read police reports and you read between the lines. And so what we see in court, as law enforcement will tell you, is not often what really happened at the scene. Law enforcement has valuable information as to what's going on. Most of us are not up at 2 o'clock in the morning, but law enforcement may, especially in your smaller jurisdictions, say, you know, I saw participant A out at 2 o'clock in the morning, and we need to know why that is. It may be based on that information that we do a series of drug screens, but we would not have found that out had it not been for law enforcement being a part of our training. And so law enforcement saves us money when they are on. The research tells us that when law enforcement's part of our team, our recidivism is reduced by 88%. When law enforcement attends court sessions, recidivism is reduced by 83%. This is good research. Now, here's one of the things we need to be careful about, and this is a case that comes out of Montana, so I'm pretty sure you all have read this case and you're aware of it. But when law enforcement's on the team and participating in staffing, then they cannot go out and take that confidential information and investigate and charge participant with new crimes. So this is something to talk about early on when they come into the team. How are you going to handle these situations. And what is this going to look like? Now, like most cases, when you look at State versus Plouffe, 2014 case out of Montana, the facts were pushing the line a bit, if you will. And so the prosecutor charged the treatment court participant with a new crime based on information learned in staffing. What happened was the participant actually admitted to stealing eventually drugs from his grandmother and then tested positive for those drugs. When the staffing was talking about that, the coordinator and law enforcement met with the participant and told the participant that he, I think in this case, needed to be honest about where the drugs came from. Well, the participant was faced with this kind of quandary about, I signed an agreement to be honest. I know honesty is a part of this program. And yet I have this Fifth Amendment right back here that I should not have to say things that are self-incriminating. And the participant, based on the conversations about, you agreed to be honest, you agreed to tell us what's going on. The participant did tell the team members that he did steal these drugs. That information was used to build a case, and the participant was charged with that crime. And the court sent this back saying that's not appropriate. Again, the crux of it is because the participant now has to choose between this value of being honest and his or her Fifth Amendment rights against self-incrimination. So important to remember. One of the ways we get out of trouble on these is let's not wait on some of these things that we know are going to come up. We know this is going to happen. It happened in my jurisdiction, in Missouri. We know these things are going to happen. So we need to talk about them. What do we do in these cases before it happens so we can think these things through and look at the case law. So here's some recommendations. Close treatment court staffing in your policies and procedure manual. Make sure that we tell people coming into the court and the defense bar or anybody who's picking up those documents that staffing is presumed closed. If we need to have a hearing or a contested matter, and we'll talk about that later, we will move that issue to open court. Implement a standing order, judges, closing treatment court staffing. And then a lot of courts do this. We did this. I like it. It's helpful, but I don't think it necessarily takes the place of having good consents with good information. And that's require everybody who attends staffing to acknowledge. So it's an acknowledgement, and it has a number of set of lines where that everybody who's in staffing signs it, acknowledging and reminding us that this information is confidential and that cannot be shared outside of the staffing with anyone else. Look at the participant handbook. Make sure that the participants are aware they do not have a right to attend staffing, and control attendance at staffing. This becomes harder in reality than it does to just say it. Key team members. If you have somebody who needs to come in, let's go back to the child and family services example. A lot of times our people have correlating cases, with children who have been removed, and they're working on getting their parental rights restored or getting those children back in the home. The child protective specialist may want to come into staffing. That's okay. They may have information. Make sure they're on your consent, because we don't redisclose, but also make sure that that individual comes in for that particular case, and then they're allowed to leave. When we're moving quickly and things get a little bit chaotic, this sometimes becomes something we think about, I didn't do that, and I should have remembered to excuse that person. So these are just reminders on things we want to do. Again, don't charge participants with new crimes based on information learned in staffing. People, I'm not talking about this being immunity from any kind of prosecution ever, but we need to build our cases independent of confidential information that we've learned. And then confidentiality principles apply to all team members. Generally, it does not apply to lawyers. Defense attorneys and lawyers talk all the time. Prosecutors and defense attorneys talk all the time about sending their people to treatment and going to treatment and how they're doing. But it applies to us in treatment court settings because it applies to our providers. So we need to be aware of that. And we also are holding ourselves out. We're a little different in treatment court. We are intimately involved in that treatment process. So arguably that brings us under that umbrella also. So let's talk about conduct. We're just going to talk about this quickly. There's a host of cases. One thing I learned talking to Judge Bill Meyer, who's traditionally kept all of this legal update up to date for us, all these cases, is that Google Scholar is really, really helpful. And so you can go onto Google Scholar, you can go onto the case law, you can click on the cases you want to be notified about, and you can actually put into that Google Scholar section, you can put in your email and then put a query in like all drug court conversations with courts, and that will Google Scholar will monitor that for you and then send those cases to your email. It's really helpful, and it's a cool little tool to have in mind, especially defense counsel, public defenders who are overworked and busy, or prosecutors or judges. So I get that. I think yesterday I got 3 cases from across the country talking about treatment court. So I need to look at that this afternoon. So this is a good way to stay on top of this. So let's talk about ex parte communication. We're going to talk about impartiality and our defense attorneys. So ex parte communication, for those of you who are not judges, who may be treatment folks or coordinators on this session, it's whenever the judge receives information about a pending case from one party. Happens a lot. And give you an example: coordinator, defense attorneys walking down the hallway, runs into the judge on the way to the restroom, whatever, and says, oh, by the way, you know, so-and-so who's a case that we've got set, I don't know where they are, and they may not be there tomorrow, and you've got, you know, that case set for 3 hours. Well, that's arguably ex parte communication that the judge then needs to tell the prosecutor and defense attorney. So both parties need to be present whenever the judge is receiving information regarding a pending case. And all of our treatment court cases are pending cases. Now, understanding that drug courts are a little bit different and judges do receive a certain amount of ex parte communications, the judicial canons have changed, and I looked up your Montana judicial canons, and they do include this provision, and that is that a judge may initiate, permit, or consider ex parte communications when authorized by law and serving on a therapeutic or problem-solving court. So we just need to be aware of these things. There are times that the judge may stop you from talking about something because it may be ex parte. This is an ethical violation for judges, which put us at risk of losing our position. So we need to be careful about those. So think about it. Again, think about these kinds of things. They happen all the time. How many times, judges, do you have a participant come up to you in staffing and say, Judge, you know, looking kind of around and off behind them, and they say, Judge, I really need to talk to you alone. Can I stay after court and talk to you? And of course, the answer is no. Don't bring them back in chambers to talk to them, but this is still court, and we still need to maintain those ethical boundaries. And so you see some examples here of ways that we can make sure those things include everybody. Everybody's on that email address so that we are not receiving ex parte information. And then conduct with participants. Now, I'm going to tell you, you know, we can kind of smile at some of these now, but when we started doing treatment court, we didn't have a lot of guidance. And I can tell you stories about judges who are incredibly good judges and leaders in this movement who did these things, who were so involved with their participants. But we know now that's going to get us into trouble. So don't take participants to support meetings. Happen. Don't visit participants at home. It's happened. Don't invite the participants to your home to play video games, and do not collect UAs. And so these things actually have happened. We know that. Just reminding you, watch your relationship with participants. Sometimes it's not this clear, is it? You know, you see the participant at church in my area, you see them at Walmart. So, you know, we need to be sure that we're aware that the information we're receiving, and that we keep that appearance of impartiality, and we are not collecting information. So the conversations at Walmart can be short, but, you know, occasionally I've had to remind a mom or the participant, you know, I really can't talk about that with you. I care about how you're doing, but we really need to keep that for court. And then again, this is just more of this conversation. There was a judge in New Jersey who was removed from office just real quickly. What had happened was he went to a picnic of somebody who was under, this individual was under federal indictment. The individual was a community leader, and the judge had attended this yearly picnic for 20 years. Everybody went. The judge went, and the news media was there. And then, of course, a complaint was filed with the Ethics Commission with the judiciary for this judge. And he was sanctioned for attending that picnic, even though he knew the defendant personally and had attended the picnic forever and did not intend to send any bad message. The Ethics Commission said that was inappropriate and sanctioned that judge for doing that. So we need to be aware of what we're doing and where we're going. Defense attorneys, I'm just going to say, we could talk about this for an hour. We could talk about it all morning. You have the hardest role on the court. And so it is up to you to ensure that rights are protected. Most of us as judges want you to say, Judge, remember, we've got a constitutional issue here. And I love advocate. So we talk about treatment court being non-adversarial, and it is non-adversarial. That's one reason it works. But non-adversarial doesn't mean not advocacy. And so for those of you who may be sitting here and you're not treatment folks, and you sat in a staffing when your treatment team member says, well, wait a minute, I want to know, did this really happen? Have you checked your records? That's not picking at you. That is protecting the participant's interest. And defense attorneys can never abrogate or can never step away from their responsibility to zealously represent the interest of their client. So understand what you are hearing from defense attorney is from this perspective. And it's important that they be that perspective on our team. So let's stay in our lane. Let's respect each person's responsibility on this team. And I'm just going to say, maybe give a good thank you to defense attorneys who are willing to try to walk this line. It's the tough one for our defense attorneys. You see some other suggestions on how helpful defense attorneys are to our drug courts in general. You play a big role, so I encourage you to look at that. And let's move on to more. One of the things that defense attorneys who are on treatment court do is they really understand treatment court concepts. So they're attending the treatment sessions. They know about eligibility criteria. They are a part of making those policy decisions. And they advocate to broaden eligibility criteria, if you will. And we've become a real asset as treatment courts as we've moved to that high risk, high need population. So defense attorneys have that same obligation. There was a case out of Florida, it's an old case, where the court said for defense attorneys to fail to become aware of treatment court and use it as a tool in their toolbox is to become a legal dinosaur. And that court was actually considering ineffective assistance of counsel claim for not looking at treatment court as an option. And that court did get remanded back to the trial. That case did get remanded back to the trial court. So now let's go to constitutional and our overview. And we're going to look at these topics quickly. So let's talk about medication-assisted treatment. What I love about us in this field is that we do this evolution, so a new concept comes that challenges what we've thought or believed in the past, and all of us dig in our feet, myself included, and then we began to listen and we began to learn. And this is an issue that hopefully is becoming less of a heartburn issue for us as judges and legal people as we learn more about medication-assisted treatment, or MAT. And what I want to say to you about this going into it, it's not just naltrexone or Vivitrol, which a lot of us kind of made that first step from no medication-assisted treatment to naltrexone or Vivitrol, because it blocks any kind of high, if you will, or any kind of physical response to a drug. But Suboxone, methadone, those kind of medications are appropriate also, and they serve a purpose. I'm not a medical person. If you've got some concerns about this, there is an online course with NADCP, NDCI's website, and it is excellent. I've watched it. So if you want to know the science and it's digestible in short bits, go to that online course and get that information. But the answer is an unequivocal no, we cannot. And the case law, this is one of those areas where the federal courts who are looking at these kind of allegations against us are finding liability. So we need to pay attention to this. If for no other reason than you don't want to lose your house, or you don't want people to get in trouble, or you don't want to lose your position in office, we need to pay attention to this. So here we go. Courts, your treatment providers, if they are receiving federal funds, and I know Montana does. You know, I've known Jeff Kushner for a long time. I won't tell any stories on him. I promise not to. But Jeff is working with you all. I had the opportunity to work with a court who got a federal grant that Jeff's helping them with. That's federal funding, court. And so you cannot deny. In fact, Jeff had to tell the federal government you would not deny access to an eligible participant's MAT. So you cannot deny access to medication-assisted treatment. We're not doctors, and so we're not deciding which medication is appropriate. Nor can we mandate discontinuance of medication. So I've seen this a lot. I've seen courts who are like, well, okay, you tell me I have to let them use MAT, but I want them to titrate off of that. That's not medically sound information. That's criminal justice, but we're not doctors, and it's malpractice for doctors to do, for us to act like doctors. So here's your studies. Again, I will point you to that online resource in the interest of time. But you see that MAT is supported by the science and research. It's well researched. And so take the time to learn this. And let's go on and talk about, well, then can I ever prohibit MAT and still keep my federal funding? Well, yes, under some of these conditions. So it is very, very narrow, but it does happen. I'm going to read the bullet points to you in just a moment, but an example of this is someone who received a prescription for Suboxone maybe a year before they came into treatment court, and the individual comes into treatment court, and enters the court not under that prescription, and then decides, this is what they tell the court, they've told me, I know you've heard it, judges, tells the court, well, I tested positive for Suboxone, but I have a prescription. Well, they had a prescription a year ago, but that's not a recent prescription, so that's inappropriate use. And so that would be a time we could prohibit the MAT for the inappropriate use, not administered as part of a diagnosed issue. You see that here, by a prescriber who has given them a valid current prescription. And what I want to say here is what I just said, is that prescription can't come from one they allegedly had in their back pocket and held onto it in case they needed it. So the prescriber has determined that this is an appropriate treatment. So what does this really mean? It means that as long as the doctors are involved in this and they are prescribing that medication, we need to go along with that. We are not experts. All right. Here's the heart of this. There's a 2011 article, and that was before we saw any of this come down in the courts, and it was written by the Legal Action Center. I think you can still get it on Google Scholar. It is referred to in our law tab at ndci.org. And what the author of that article and lawyers are doing now is looked at whether these prohibitions violate any constitutional or statutory rights, and the answer is yes, they do. Again, we can do this forever. There are online courses on this, but having a substance use disorder is a disability. It's recognized in the American Disabilities Act, and so the ADA protects access to appropriate care and medications. The Rehabilitation Act of 1973 just takes the ADA, which applies to state action, and applies the ADA to federal agencies. And then the 14th Amendment guarantees due process of law anytime you're interfering with a property right or a liberty interest. And then the 8th Amendment, cruel and unusual punishment. There's a host of cases, the line of cases, that consider whether jails can deny access to MAT. Now, we all know some of these medications are pretty expensive. And so what the current state of the law seems to be is that if somebody's going into jail and they have a prescription and they are on methadone or whatever it is, and the jail takes them off of that medication, the jail is actually engaging in activities that and the court uses some pretty strong language on this, is a deliberate indifference to the welfare of the person in custody and is cruel and unusual punishment. They've not gone so far as to require courts to pay for that, jails to pay for that expensive medication. But watch it. There's a case, and this is what we saw. There was a case that Watson out of Kentucky, and the participant, we all are aware of this, sued under this. That court survived a motion to dismiss in federal court, was ultimately dismissed. I think things worked out with them, but the fact of the matter is the court never said this was not a valid cause of action. So we need to pay attention if we're inclined to do that. And I love this. I hope, judges, that your treatment providers and those folks are on this call, because sometimes, we'll hear well-intended treatment providers still talk about, well, we're sobriety based, and that's not sobriety. And so it becomes very frustrating for the treatment provider. And so those of you who are treatment providers, let me say this, we're acting to protect you. Because what we have found in this line of cases that are suing courts for liability is that when you as a treatment provider come on this team, you are acting under color of state law. And there's cases that have found this. Now, why is that important? Because that pulls you under a statute that allows you to be sued for denying access to constitutionally protected rights. And so need to pay attention as a provider. We are protecting you when we do these things that we say we cannot do under the law. So just be aware of that. Sometimes these things go beyond what we think. And if you're really struggling with this, I understand that. It's not my job to tell you, how to feel about things, but go online and watch some of these things and try to educate yourself on why we are here. And then please listen to the attorneys and legal people who are on our team. We're all staying in our lane. We're learning not to be treatment clinicians. I'm learning to listen to your assessments. Please listen to us when we make these legal kind of judgment calls. So let's talk about First Amendment. This is one that really got a lot of pushback early on. I think we all are aware now that we cannot mandate participation in AANA, cannot mandate it, but we can offer it so long as what? There is an alternative. The courts are real clear. Every case out there says that AANA is faith-based, religious-based. Again, we can have this discussion later, but that's where the case law is. This is one, folks who are listening on this court, this is one of those areas where there was liability, personal liability found for a treatment court team member. So it does pay to listen to what we're doing. This is a big one. It'll get us in trouble. So again, attendance AA violates the First Amendment. You can read these. So here's how we address that. You must have a secular alternative available. It's not saying that we don't need support groups. We know that. We know that community engagement and support groups are a part of recovery. We support that. Here are some examples of secular-based recovery groups. They are available online, and the research is telling us that online services work. They're inexpensive and they're accessible. So use them when somebody objects to AANA. Listen and pay attention. Let's talk about area restrictions. And I think we know this, but I think sometimes what happens to us is we get into a situation where we're trying to protect the participant from themselves. And we forget that even when we're making these orders, we need to pay attention to what the courts say. So yeah, we can restrict areas that people can go into, and it needs to be related to the underlying offense or to the offender and their needs. It needs to be as narrowly drawn as possible, and related to rehabilitation needs of the offender. It also can be a public safety discussion involved in this. So just give you real quickly a couple of examples of where the court has been and what they found. The courts found that it's okay to deny access to the French Quarter in Louisiana for someone who was convicted of prostitution. The court found it was not okay to require a woman to move out of her neighborhood. It was a high crime neighborhood because she had lived in that home for 24 years and did not have the means and the financial ability to move out of that home. So the court said that was too broad. The court said it was too broad to require an individual who had a conviction for a sex-related offense to be prohibited from, quote, all parks, all schools, and all forced reserves. And that case is People versus Rizzo, Rizzo. It does a nice job of giving you a kind of a discussing how this area restriction plays out and what's appropriate and not. It looks at Supreme Court cases, so it's a good case to go to. There should be in your area restrictions a means to enter the area if it's necessary, or make sure there's a finding there's no less restrictive means. And what that looks at, for example, is a case out of California where a young person who was involved in gang-related activities was prohibited to go into a certain part of town. That was okay, except for the fact that grandma lived there and she was the one positive influence in that young person's life. And so what the court said was that was too broad of a restriction. You need to, court, allow the young person somehow to have access to grandma. So entry into that area under very limited means and maybe supervised means. So keep these things in mind. It's appropriate. Make it narrow and look at whether there needs to be some exceptions. Let's talk about association restrictions. We also know that we can do that. And the court's been pretty good about looking at pretty broad language and upholding it. It's okay, quote, consorting with felons has been a valid finding. No association with individuals with a criminal record has been upheld. In California, though, there was a case which had a requirement, no association with gang members. And the court in California sent that case back saying you need a knowing provision in there. And so I think what the courts have looked at to kind of give us an example is it's direct and indirect contact is okay. That's okay to prohibit that. But sometimes that slides into incidental contact. You know, I saw them across the parking lot at Walmart. So that's where that's going to cut when you get these things in front of you and you're making a decision. Was it an incidental contact, or was it an indirect contact? You know, grandma is going to contact the ex-girlfriend and ask her to call. That's not appropriate. Where we get into some issues that we're really looking at now is marriage. We recently had a case to NDCI that talked about somebody who got married in drug court after the court said they didn't want them to have contact. This is a tricky one. I'm just going to be honest with you. Again, one of those areas where that, we kind of know, I guess, practically what we want to accomplish and why, but the courts are looking at this through heightened scrutiny. As Judge Spencer, who's on our faculty and teaches law school, says, this is strict scrutiny. So judges and lawyers, when you restrict marriage rights, think about meeting that strict scrutiny overview, because that's what the courts are going to use to look at. And so generally the courts are finding that we cannot impair that marriage right. It is a fundamental right. It's been considered by the courts to be a fundamental right. Alaska case, two individuals involved in a relationship, in a marriage, were dealing drugs. Court said they could not have contact with each other on probation. Alaska said that's too broad. They were married and that interferes with that fundamental right. Huff is a case that recently I found, and the court prohibited cohabitation between two individuals. And the court struck that down, saying that cohabitation was not related to the crime at hand. Prohibiting contact was upheld by a case in California. It is Junger, Junger, and that was a domestic violence case. And even there, the court allowed some contact. As it happens with domestic violence, the individuals married after the no contact provision went into effect. And what the court says was the spouse who was under probation services could not contact the complaining witness. However, the complaining witness could contact the spouse. Nightmare to enforce, isn't it? But that's where we are. A family services case, father of child, woman told could have no contact with father of child. Quote, here's how come it was upheld until further order of the court. So there was a provision for the court to be able to review that. So just keep those things in mind. Constitutionality and Fourth Amendment searches and seizures. We know that. We know that probationers have greatly diminished expectations of privacy. A lot of our folks in treatment court, since we've gone to high risk, high need, are on probation. So they have a less expectation of privacies. The protection here is the search cannot be used to harass the participant. What I would ask courts to be aware of is if you still have people coming into your courts who are on a diversion status, so they do not have that conviction, they have a wider range of rights than here. So we need to be a little more aware that we don't have quite the ability to search at the level we do for probationers. Now, where I find this is that bond, when the courts have looked at this, these restrictions or these search waivers as a condition of bond, the court is looking at your enabling statute. And does the statute in your state allow you to impose more conditions of bond, additional conditions, drug testing, treatment, that kind of thing. So look at your statute and see what you're allowed to do and what that looks like. But be aware there is a difference between a probationer and somebody on bond or on OR release pending this case. I want to talk real quickly. We're going to run out of time. I'm sorry. Due process. Anytime you're impairing somebody's right to liberty or property right, they are entitled to due process. That means those of you who are not lawyers, those whole things we do in court, that litany, that person has a right to be heard, to present evidence, and the court makes a decision based on the evidence at hand. So here are the few due process requirements. We know these, and these are the requirements required in probation violation hearings: written notice, right to appear, independent magistrate. Tuck that one in. I want to talk about that in a moment, because that also bleeds over to what? The impartiality that we talked about, that appearance of impartiality. It's kind of two sides of the coin, for the court. So you see these rights that are required. Termination hearings must be afforded these rights. There are courts that have gotten in trouble for failing to do that. So the question becomes, if I terminate somebody from my treatment court, if I terminate them from treatment court, do I have to get off of the case on the disposition? And the answer is not necessarily. The only state that actually requires the treatment court judge to get off of that case and let somebody else hear the dispositional hearing is Minnesota. We recommend that you take a very cautious approach and follow Oklahoma's example, which is that you as the judge can hear the termination hearing, you can hear the probation violation hearing or the sentencing, but if the participant wants you off the case, then get off. It's just that simple. And so that's our recommendation. It keeps you out of trouble. And that doesn't happen that often. So again, these are the recommendations. You see that when we look at the notes, most of us across the country that I've taught with who are judges, and I'm sure your experience is this, very, 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 very rarely did anybody want me off the case. Because when they went across the hall, the judge did not have the knowledge of treatment, did not have the knowledge of substance use disorder, and the results were always much more negative. So it's not going to happen that often, but let them know that. So what about sanctions? A lot of times when we're talking about a sanction, the participant wants to talk about why the issue happened. So it's more about mitigation than it is about denying the factual basis. But I'm here to say they need to be able to talk about mitigation too. You know, if you're good at motivational interviewing, that's a wonderful conversation that can be very therapeutic. And judges ask your treatment team and staffing. I did a lot of asking how do I phrase this message so it's therapeutic. So it may be about mitigation, but whenever the participant or the defense attorney tells you that the participant says this issue did not happen, they are entitled to a hearing in court. They are entitled to a hearing in court. Judges have gotten in trouble for this. It does not slow you down. So they must have a hearing. It guarantees due process. And can I also tell you, this happens very rarely. It can happen quickly. So put those probation violation protections, you know, the notice, the hearing, the counsel, all of those things we just talked about, those are in play for a sanction hearing, but it's not a formal hearing. So you don't have all of those array of rights. You know, the evidentiary protections are there, but you can hear, you know, you can take into consideration things that would not be admissible in a trial. So look at the law on probation violations. It's a lesser standard, but they are entitled to a hearing on that. And so here we go. Don't violate participants' constitutional rights, or we can be sanctioned. These cases are available. You see that site down at the bottom. You can find these cases on the internet. Again, there were a host of counts on these, or a lot of allegations, but this judge was removed from office. You know, jailing participants for long periods of time. Refusing to conduct jail sanction hearings. So make sure we do that. Let's talk about preventative detention. This is one that's really hard. We cannot do preventative detention. So if you're putting somebody in jail purely to wait for a bed date, do not do it. You will get in trouble. The courts are clear. You will be talking to a federal judge about this, and you can lose your right to office. Can't do it. Can't do it. I worked with a leading treatment person, a psychologist with Judicial College recently, and he said what you do if treatment's not available and a bed date's not available is you put them in a lower level of care while you're waiting. All right? Jail is not treatment. So we need to be aware of this and pay attention to this. Class action lawsuits, please, please, please do not do this. This drug court was shut down. The judge was removed from office, signed an agreement never to hold a judicial position again. The case was ultimately dismissed on technical grounds, but not because there was not a cause of action. And the folks in this case were team members who were also sued. So team members, pay attention when our legal people say we can't do this. I love y'all. I'm not trying to be mean. I'm just trying to protect you. So keep this in mind. This court in Indiana, this was also certified as a class action. You think people won't sue you? It went from 1 participant to 63 of the drug court participants. So here's our due process recommendations. Hold a hearing whenever we're dealing with this. You know, here's the thing. Usually when people are using and they need to, and they are back where they need a level of care that's residential treatment, they are engaging in other behavior. I'm just going to cut to the chase on this. So you may have someone who needs treatment. If the only thing they're doing is struggling with using and they're not causing any other community issues, don't put them in jail. However, often what happens is they abscond, they fail to report to their PO, they're not attending treatment, so they have what? Other probation violation hearings. If you think custody is appropriate, you must treat this like a probation violation hearing. Give them notice and hold them because they are engaging in other behaviors that put the community at risk or you know, are not compliant with the conditions of probation, like we just talked about. Make sure you set dates. Set that matter for a hearing. This is not an excuse to hold somebody. Don't do that. If it walks like a duck and talks like a duck, it's a duck. But often, most of the time, when this happened, unfortunately, there were other things going on. I had to issue a warrant and go get them because they had failed to report. So consider these things, and once they're in custody, they are to be treated like a probation violation. So look at what you've got. Teach your team. I teach my team. I don't want to hear you say for their own good, because that's not a valid reason to hold somebody. So this is Judge Oliver Wendell Holmes. We may disagree as to what due process and when it applies, but we need to always embrace the concepts of fairness and opportunity to be heard. So whenever we have these things that fall in gray areas, and they do, no matter what we talked about, next week you're going to go to court and it's going to be something we've never talked about. Well, what about this? Let's fall back on our principles of fairness and opportunity to be heard, and to protect and be cautious about what we're doing. I did a lot of referring to resources and sites. This is our last slide. This is the law tab at ndci.org. It is updated. This is fabulous. Please go there, those of us who like easy legal research, and you will see topics. When you click on the topic, cases holding that mandating individuals to AA is a violation of First Amendment. You click on that, those cases, it'll drop down box and it'll give you the cases. And not only will it give you the case, when you click on the case, it will take you to the case so you can read it. Wonderful research. Please use it. And please use those other online sources and resources. If you've got questions about, treatment and MAT, use those. They're really good and they're there for your benefit. Deep breath, everyone. I think I made it in an hour, maybe a minute over. Shane, I'm going to turn it back to you, sir, and I'm going to stop sharing.
Well, thank you so much, Judge Davis. Fantastic session. There were lots of questions. I'm sure there'll probably be more. Unfortunately, due to our time constraints, we don't have time to answer all those questions in person, but I am sending an email to Judge Davis with those questions, and she will respond, and Jeff will send it out to everyone after she gets it back. So thank you again, Judge Davis. It's been a pleasure. Everyone, we are going to take a 15-minute break. We're going to be back here at 9:15, and we'll start up with Michael Clark on motivational interviewing. So take a break, stretch your legs. Thank you again, Judge Davis. And see everyone soon.
Thanks, Judge. Appreciate it very much.
Thank you, Jeff. It's hard to do it in an hour, isn't it?
I know.
Yeah. I'm going to read the chats before I get off. So you all go ahead. Shane, my chats went away. I won't read them. You'll send them to me, right?
Yes. Yes.
Okay. All righty. I'll see you later. Thank you, guys.
All right. Thank you. Thank you.
Yes. Welcome back, everyone. We are excited for our last session today. We will be having Michael Clark, who will be talking to us about motivational techniques for treatment court judges. I know we have many people in here that are not judges, but motivational interviewing is really something that the whole team should be aware about, and especially have training to really engage the client. So I'm going to turn it all over to Michael. If you do have any questions, be sure to write them in chat. I will be collecting them and we'll have an opportunity to discuss. Thank you. They're all yours, Michael.
Okay, thank you, Shane. Hello, everyone. Yeah, I'll tell you, I am really, really glad to talk to all of you. I was around in the 90s when we were starting to set up a lot of drug courts. It was quite new, therapeutic jurisprudence, and And even back then, the judges that I met that started into this field were different, and different in a really good way. I know you take on a lot. I know that sometimes you take on more than you should. But what I want to do is I want to use this hour to give you techniques. And Shane, you're right. This isn't just for judges, magistrates. Anybody can use these techniques that I'm going to be bringing you today. I want you to remember to write down any questions. I'm going to give you a good 10 or 15 minutes at the end. If you have any questions, then please submit them. Make sure you write them down because I'll be giving you time at the end. Another thing I want to tell you is that I am going to be submitting this packet of materials to Shane, and I believe Shane is going to be giving them to the judge to distribute to you, okay? I also want to start with a little bit of humor because as a treatment court judge, you don't always get a little bit of humor. Did you know that in Michigan, there is beta testing being happening for a written alcohol roadside test? Yes, folks, a written alcohol roadside test. And the initial results is that it's going to be pretty effective. Yeah. Look, if I don't keep you laughing, you might start crying. So here we go. I want to talk about this. I want to talk about the treatment provider versus the treatment approach. Listen, let me liken it to this. How about if I were to liken it to this? Is it when you enjoy a delicious meal, is it the fresh ingredients that were used or was it the chef? All right, so when you talk about treatment approaches, historically, outcome research has always pitted two treatment approaches against each other, and it's kind of a horse race. And I got to tell you that more oftentimes than not, they end up just about the same. But what I'm interested in is the provider. I'm interested in what's going on between two people that are talking together in the same room. And today I'm interested in what is going on between you on the bench and your defendant in front of the bench when you might only have 2 or 3 minutes to talk to them. But having said, let me show you the past research. The past research was almost all ingredients, very little chef, right? It really was all about the evidence-based practice. It was about what we call the technical aspects. And now the recent research has said, well, wait a minute. It's the fresh ingredients and the chef. So now they've added relational factors along with the technical. And I'm going to tell you something right now. I've been waiting 20 years for this research to come into corrections. The human services field, psychology, social work, child welfare, they've known about relational factors for decades. The American Psychological Association a few years ago said that they would no longer fund any grants that looked into whether the relationship between provider and participant was effective because it's a done deal. I had chance to talk to an APA board member, and I kind of had a little look of disdain on my face. And she said, "You don't agree with that, Michael?" I said, "Well, come on. I mean, it kind of harkens back to the dark ages." She said, "Oh." She said, "Well, if you were the National Geographic Society, would you think a good use of your grant money would be to fund another study on whether the world was round?" Oh, okay. I mean, it's a done deal. The relational factors are very important to outcome. Know this much. One of the reasons behind why I'm doing this hour with you is to get you to use this time in a better way. In a lot of the clinical trials, they will have multiple sites, okay? They have like 4 or 5 different sites where their approach is being used. In some of these sites, folks, there would be providers that would be up at the 80 to 85% success rate. Other providers were down here at the 20% success rate. And what would they do? they would average out the site and say they were all 60%. What? Why wouldn't you study the 85%ers? I don't know. The emerging research is really optimistic because now we're looking at 2 chefs using the same ingredients. And now the research is really getting interesting because now we're finding just how important relational factors are. This has been really something because actually research has dismissed this interaction that I'm going to be talking about today. They call them non-specific factors. No, we know what they are. We know that they're compassion, affirmation. We know that they're positive regard. We know what these things are. They call them common factors, like they were always present. No, they're not always present. Before COVID, when I would be out training around the country, somebody would raise their hand and say, Mr. Clark, I have a really high caseload. Like, can you do motivational interviewing in 5 minutes? And my answer would be, look, if you were a piano player, could you play piano for 5 minutes? Well, of course you could. You could play beautiful melodic piano for 5 minutes. But then I would answer a question with a question. I would say, can you ruin motivation in 3 minutes? Yeah. So the time you spent with a defendant in front of your bench is truly important. And that's what I want to work on today. Here's a book. This is part of the Bill Miller and Steve Rolnick, the Model Originators. This is one of their series. This was 2 years out of my life, let me tell you. And I want to tell you that here's something I want you to know, as well as your treatment team staff. Motivational interviewing was created for those more angry, resistant, or reluctant to change. And back when I was the chief probation officer and the magistrate here in Ingham County, Lansing, East Lansing, Michigan, I knew that I had a lot of that on my caseload. But here's some quotes out of the book. And these are quotes that people would come up to me, and out of my whole book, this was the quote they wanted to talk about. And here was one of them. It is exhausting to try and get people to do things that they don't want to do. And our field is exhausted. Whoa. Boy, did that resonate with people around the country when I would run into them. And here's another one. I'm not going to repeat myself twice, more than just a couple of times, but here's one. Change doesn't have sides. Compliance has sides. Absolutely, compliance has sides. But we've got about 4 to 5 decades of research on how to gain compliance. I'm talking about if you've only got compressed timeframes with the defendant, what can you do that might help behavior change to take root? Because change doesn't have sides, right? And motivational interviewing has both. It has technical and relational factors. Folks, my personal history was I was drawn to the strengths approach. When I was a new probation officer at my court, it made sense to me. I saw these heavy-handed people being really rude and really yelling, and I thought that can't be the way. But I knew this much. Pain and problems get the ball rolling. Pain and problems are why defendants end up in front of your bench. But that's not the same as saying that they finished the job. What will finish the job are people's strengths, assets, past successes, their values, what they aspire to, where they've made mistakes in the past, the skills they might have, right? So we've got to be able to move over. But here's where motivational interviewing came in. I knew to be strength-based with somebody. But what about the person that came in and said, I love meth and I want to keep smoking it. I don't care what that darn judge says. Okay, I knew to be strength-based with that person, but what I didn't have was a directional piece to move them away from the meth. And that's where strength-based and motivational interviewing kind of came together for me. Then it started to really make sense, and it was a really good find. Motivational interviewing has those technical factors, but they also have relational factors. They sum these up in the acronym of PACE, because they say, yes, we've got a skill set to use this. We also have a mindset, but make sure that you know that we also have a heart set. And PACE boils down to this: partnership, acceptance, compassion, evocation. When we talk about partnership, we're not talking about being friendly. That helps, but this is a professional relationship. This is where you have, this isn't something that people have been doing since they entered public school. This is a different type of partnership. And we say, you start with engagement or you don't start at all. That's what the research tells us. And for acceptance, you see it broke down into 4 different categories. I don't want to talk about all of them, but I want to say this much. In regards to absolute worth, what I want to say there is we ask a very personal question of any treatment team that goes through motivational interviewing training, and that is, people that are involved with drugs and alcohol do some pretty heinous crimes. They hurt self, but they also hurt family and they hurt children. And what we need to ask is, does these hurts, do these crimes, do they take away from the person's humanity? And it's a personal question that has to be answered by the person, the student in our room. Motivational interviewing would say it does not. And the other thing about affirmation, affirmation is not fluff. Affirmation is not fluff. Since they're going to move on and solve their problems through their strengths, we better have some affirmations ready for them. And we're going to talk about those as we go on. So here, participants, the most important reasons for entering the drug court. Now, judges, I want to tell you that this was research I ran into 99, 2000. And it was, why do people enter drug courts? Well, you would probably be able to almost pick out these answers. Here they were in order. Chance to have the charges dropped. That's not a surprise to you. They didn't want it. They didn't want the consequences of jail. They did want treatment. They wanted to get a job, and family was always important to them. But this research went farther, and they asked the graduates, why did you graduate? A lot of people didn't. A lot of people dropped out or were kicked out, but you stayed and you graduated. Why did you do that? Now watch how these answers came back. Let's start at the bottom. The first one was, the possibility of sanctions ended up last for why they stayed. Then came the frequency of your analysis, because some people saw that as a help to them to get them started. Then came the frequency of treatment sessions. But the number one issue of why they stayed and graduated was you. Was your relationship with them and their relationship back to you. Now that's some powerful stuff, judges, and that's why I'm so glad you're here today. So when you go to this book and you think about motivational interviewing within your team, know this: it tells you what to do, but just as importantly, it tells you what not to do. And I got to tell you that we've done a lot of research in motivational interviewing as it's been applied in the courts, excuse me, as well as drug courts. And I got to tell you this was really important, because as trainers, when we couldn't get a staff person at your court up to competency level, up to a level where we said, yup, they're doing motivational interviewing and they're doing it with some quality. If we couldn't get people up to that level, here's what we found. Indirectly, they got better. How did they do that? They dropped 3 or 4 of the worst relationship rupturing behaviors that they would engage in all the time. And indirectly they got better for what they dropped off. Maybe not what they gained, but what they stopped doing. But I gotta tell you, when I came out of Michigan State University, I came out ready to go to work, I'll tell you, and I got the job with our local court. I was as happy as could be. So my first week on the job, paper thin walls. And there was an older man that had an office next to me. And folks, you know the staff person I'm going to talk about. He was angry. He just would go after people. So think about what I heard all day long. This is my first week. All day long, excuse me, what I heard from this man was and believe me, I heard it coming from everybody in his office, his clients and him, arguing, yelling, combativeness, upset. This guy would come into my office midway through the morning and he would hang his head and he would go, "This job." And even as a rookie, I wanted to go, I bet it's hard for you. But think now. Now, as I've gotten older and as I've read more research, think about this. Everybody that went into that man's office was different. Different genders, different backgrounds, different value sets, different experiences. Different mental health issues, different severity of their issues, different drug issues. So how could all of the conversation that I heard coming out of his office, how could it always be the same? It was him. It was him. And that is the premise of what this hour is today, is to talk about what we can do, what you can do in the short amount of time you have. Now, I want to tell you that adding relational issues, here's a brand new, this is a 2021 article, all right? We talked to Dr. Okafanua. He found a 13% reduction in recidivism by taking a group of pretty dyed-in-the-wool, tough nut probation staff and giving them about 4 hours of training in compassion and empathy. Now, it wasn't that he was able to lower recidivism by 13% with kind of a tougher group. That was pretty impressive. It was how little training it took. We're not talking 4 days, we're talking 4 hours. And he lowered recidivism by 13%. This is happening and it's good. It is good. So let's get on to these judicial techniques. I'm sorry it's taken me so long to get to them, but let's start into them because I want to give you 3 types. And these come from the brief therapy models. This also comes from motivational interviewing. Some of these come from the brief family therapy field. These are not therapy per se. These are good techniques that you
Michael, can you hear me? It appears that you have frozen. I do apologize, everyone. It appears that his connection, something is going on with his connection. So hopefully he will be able to join us in a moment. So I'll wait for Michael to rejoin us. Hopefully he'll be back with us very shortly.
Shane, is there any way to get in touch with him? He may not know it.
Yes, he has completely exited, but I have texted him.
Okay,
So hopefully he will be joining us or relogging back in.
Three types. So here we are going for three types, and I wanted to start with those experiencing trouble or those regressing. First off, survival questions. How have you learned from any mistakes you've made in the past? Judges, explore what lessons they've learned from adversity. You and I know that they've been in trouble before. They've had people that have been working with them before. How have you survived thus far is a good question to ask. Sarah, what did these troubles teach you about what to do now? Sarah, you've had problems before. You've been in a couple of courtroom settings before. And what did you learn that you could apply right now in our court with our team? Setbacks are guides. They give you helpful feedback. So let's use them, right? They also offer a lot of information about their environment, external resources, what kind of hope they have. In the materials, folks, that I'm going to be sending to Shane and to the judge to be distributed to you, I'm going to give you a single page on research into hope. The beautiful part about relational factors is that now PhD candidates are starting to study these elements that we know are involved in good outcomes. And if you would have said to me, hey, Mike, what is hope? Well, I would have given you a couple of these elements that they found in this research. They found 5. And when you read these, you're going to say to yourself, oh my gosh, if we are not assessing this, I don't know that we really know the person. Okay, next up, exception questions. Ooh, I like these. These are wonderful. Clients don't notice exceptions to the problem. They believe that the problem is happening 24/7. And folks, they're not. They just aren't. Almost every problem has an exception. The bully doesn't hit. The truant goes to school. The user doesn't use. There's always times of exception. Now, before I learned these techniques, before I learned motivational interviewing, I used to ask questions like, when does it get worse? No, I don't ask that question anymore. I ask these questions. When does it not happen? The other issue is I want to tell you is that most of the time people will tell you it always happens. There are never times of exceptions. Here was an example. I was working with a guy, let me say it was a married couple. And the wife, I was talking to the wife of the participant in our program, and she said, I got to tell you something. I think my husband has like a a social disorder, like an avoidant disorder. He's a hermit. I said, oh, tell me more about that. Well, he doesn't leave the house. Matter of fact, he hangs out in his bedroom. And sometimes I've even found him in this big walk-in closet. I think it's just like, don't you think that's weird? Okay, settle down. So I said, are there times that, she goes, no, he's always here. Judges, if you have somebody say there's no exception, walk them back. What was it like this morning? What about last night? What about yesterday afternoon? What about yesterday morning? I found so many exceptions within 36 hours that I turned to this woman and I said, well, ma'am, your husband is a hermit who's never home. Yeah, she says, yeah. Okay, it just enters a different kind of an idea, all right? It breaks, it's like a shoehorn to open up a little bit of room. But remember, exceptions have to be purposeful. If one of your drug court, your treatment court participants say they haven't used in 4 or 5 days, and you find out it's because the dealer was on vacation, that's not a purposeful exception. So let's make sure you know what they did to see the success, right? Okay, the 2 doors metaphor. This is where I got sold short in my university training. I tell you that I was literally trained that the problem had to be eliminated. It had to be defeated before the solution could take root. And that was not true. That is simply not true. They can both coexist. I want you to think about a 2 doors metaphor. The problem and the solution can coexist. Hey, Karen, look, it's okay to feel shy and it's okay to go to group therapy anyway. Eddie, it's really okay, Eddie, to feel hopeless and it's okay to just keep going. George, I know what you're saying to me right now, and it's okay to feel like you can't do it. But George, it's also okay just to keep coming back. Just come back tomorrow and try again. 2 doors. Don't fall into that trap that I did, that the solution has to be eliminated. That's just not true. How about split brain? Judges, I have asked researchers for the past decade on where this comes from, but it is very powerful. It's powerful because you tell the defendant you're not sure. You're not sure, but you're placing bets on their competency. Robert, I have to tell you, I'm really split about your near future. Half of me says that you're not going to be able to make your next level because things aren't going well right now. But Robert, another half of me says you've done really big things since you've been in our court and you'll be able to do it. Robert, I'm just not sure. I'm just not sure where you're going to head from here. But leave it with this. Robert, I'm just not sure, but I got to tell you something. I feel like you're up to something big. I think you're up to something good here. I wished I could give you the research behind this. I learned this technique a long time ago. I wished I could find it for you, but it's that issue of not knowing, and it empowers them in some way to show you that, to convince you. Okay, now I want to show you some techniques for participants who are losing hope or are overwhelmed, right? Here's a good one. Refer to the problem as the outside enemy. And I know this flies in the face of somebody assuming responsibility and someone taking responsibility for what they've done. All right, I get that. And I have no problem with that. But I'm going to tell you this, there's also some mileage to be made in placing that outside of someone. John, when that hassle of talking back to staff tells you to get into trouble, how will you not listen to it next time? Now, remember this, it was John who used the phrase hassle. That was his phrase to delineate what all the trouble that brought this person in front of you, okay? And what you're simply doing is saying, how will you not listen to it next time? It seems to really get after you, John. How will you avoid it? Mary, now this is Mary's words for herself. Mary, when being stupid tells you it's okay to miss important urine drops, Mary, how are you going to fight it so it doesn't hurt you next time? How will you overcome that voice that says it's okay to miss? Poof. Now, judges, don't externalize feelings, only behavior. It's not John's anger, it's what John does with it. It's not Mary's feeling insecure, it's Mary's avoidance and not showing up as she's supposed to. You want to externalize the behavior, not the feelings. That's pretty important. Next up is percentage questions. Judges, remember, you don't have much time. You have what, 2, 3, 4 minutes with someone? How do you try to dislodge them from this all or nothing mentality that they start to spit at you when they're in front of your bench? And I really like percentage questions. Bill, how much of this is you're never going to change? And how much of this maybe is that you're just really stuck right now? And then make them give you a percentage. What do you think, Bill? 50-50, 60-40? It really helps if you make them give you a number. Why? Because it has made them, by default, they've had to think about a more optimistic or at least a more solution-oriented view. Elizabeth, how much of this is that the program staff is really against you? Or Elizabeth, how much of it is that you just had a really bad experience Tuesday? 50-50, 60-40, what do you think, Elizabeth? Make her think about the fact that maybe it was just a bad Tuesday, not the program staff. Julio, how much of this is it that you can't stay away from your using buddies? But Julio, how much of this might be that you just really haven't sat down and talked with our staff to figure out some strategies yet? What do you think? 50-50, 60-40, 70-30? One question, and you've already inserted a more solution-oriented idea. Okay, now double-sided reflections. First off, using reflections for anger is usually my first response. When somebody is angry and they start spitting back at me, I don't defend, I don't review the rules. What I try and do right out of the gate is just try to understand. Boy, Harold, you're really upset right now. Harold, you just felt that was a raw deal. That kind of just listening and responding can sometimes slow them down a little bit. But I like to do double-sided reflections as well, and that's this. You know, Harold, you don't want to attend that program because you don't think it'll help. But Harold, you've also been in front of me before, and you do recognize there are some problems. I like to use the one hand and the other hand for double-sided reflections. And here's another thing. Always use the solution last, the change talk last, not the problem talk. It's called the rule of recency. And that is clients will generally remember the last thing you say. So Harold, you don't really want to attend the program. You don't think it'll help. Yeah. But Harold, you've been with me before and you do recognize there are some problems. Yeah. Now we've brought in an alternative idea. Here, relationship questions. Oh, why? Why didn't they teach me this before I got into the field? Defendants' own perceptions of themselves are good, but defendants' beliefs in others' perceptions of them can be even better. And you've had this happen. It's happened to you so many times. What do you think? I don't know. Well, come on, you must know. I don't know. What, I don't know. I don't know. Use a relationship question. Well, then, William, if you started to get better at this, who would be the first to notice? Well, probably my girlfriend. Okay, William, what would she notice you doing? William, if you were starting to make this level that you need to make, what would your friends, you got those couple of buddies that you've made right here in this program. What would they see you doing different? What would they say about you would be different about you? I don't know what it is. I don't know why it's easier, but if I ask them their perceptions of themselves, but if I ask them other people that are important in their life, what they think, they'll start to tell me. Well, I don't know, my buddies would probably say that they see me. Try it. And folks, you know your personality, you know what seems to suit. Try a couple of these and see if they work for you. So here's another one. I am not going to get into this one because you already know this. And that is, with post-traumatic stress and with all the limbic emotional brain being supercharged, the frontal cortex is not available to them as much as we'd like it to be. And there are times when I was a magistrate, I knew that person had it all down when they left my courtroom, and they didn't. Have them repeat it back. And keep it. If they have to do more than two things to remember, so have them literally tell you what was important, tell you to summarize, have them write it down, anything like that. You already know this. Just this is kind of a booster to remember. Okay. Here, emphasizing personal choice and control. I don't use this one. Yeah, this is for tough spots. I don't use this one right out of the gate. Folks, when I had to sit down with people and use what? I would use, I would have to serve probation orders. I didn't inherently use motivational interviewing for that. I don't think I ever stopped using it. But my job when I was serving probation orders was to be very explicit, very simple, get it across to them, make sure they understood, okay? That isn't where I would be using this. I would be using this when I would get that kind of really hard pushback. I don't give a damn what that judge said. I ain't doing it. Okay, when I hear stuff like that, this is when I start with this. And it's got to be, folks, because we work for a court, it really needs to be in 3 levels. Look, Ted, I got to tell you, it's your decision. You're right. You can take the consequence. And believe me, you and I know Ted can take the consequence. They take it every day of the week. How many times were people let out of my courtroom in handcuffs and they were yelling at me back on the bench to tell me where I could stick the key to those handcuffs? Okay, so they can take the consequence. I have to tell you that when I was when I was a probation officer, when I told people they couldn't leave the county or they were going to be in trouble, I was a liar. They could leave the county, but if they were caught, there was going to be trouble. So the first thing I tell them to kind of lower that anger level is, look, this is your decision. Yeah, damn right it is. But Ted, I have to tell you, I've been around this treatment court for a while. Here's what I know will happen if you don't, or if you do. And I don't use this like a baseball bat. I just state the obvious. If you and I were in a hotel lobby and it was raining cats and dogs, and you were going to go out to our rental car without an umbrella and not think you were going to get wet, how would I tell you that? I would just tell you it straight up. You're going to get drenched. I mean, that's going to happen. I wouldn't hit you with it. I would just tell you. And then there's a third level. We come back to this. But you know what, Ted? It really is, it's still your choice. Even with the consequence, Ted, it's still your choice. You've got control over this. And I would usually add, what do you think you'll do? Now, folks, I've had people in my office, and they would say things like, yeah, you're darn right, it is my choice. Okay. I would see him a couple days later and I'd say, hey, Ted, what we talked about on Monday in my office, what are your thoughts? Well, I thought about it and, you know, good, Ted, good. When somebody is locked into that anger, it never helped me to tell them why I was doing what I was doing, to tell them what the rules were and why we had gotten to this point in time. What helped me was to say, look, this is really your decision. Probation officers used to giggle when I would train this, but then I would sit down and role play with them on just how little personal control they really did have and how people can choose the consequence. So give them a choice, and it generally will get them back to some sense and sensibility. Okay, now I want to give you some more. I've got about 15 minutes. I want to also give you time for questions. I'm so sorry about that. I'm glad I haven't lost the internet. I thought, oh no, is my office building out of power? I didn't. Anyway, let's talk about for participants who have made recent progress. Because I'll tell you what, when people are in trouble, boy, we bring them in front of the bench and we roll out that carpet and we examine what they've done. And then when we do well, we kind of give them a pat on the back. Well, there's more we can do. One of them is to re-describe and blame them for success. Wow, Freddie, how did you do this? And I mean, I would ask that from the bench with some incredulousness. How did you do this? Freddie, how did you know that that would work? Make Freddie answer you. Freddie, how did you manage to take this important step to turn things around? Because, buddy, you were heading for trouble, and now look at how you're doing. Fred, what does this say about you? What does this kind of a turnaround say about you, Fred? Linger over success. My clinical word. When I went back for a master's in social work after I'd been a probation officer, well, I did it at a community mental health center. And they knew me and I knew them because all of our clients, right? All of our clients were kind of the same. Well, I had a practicum instructor, and believe me, back then, this was during the time of they had one-way mirrors, and they would have a team of therapists behind the mirror watching a family therapy session. Now, the family knew they were there, and they would sign a release of information to allow them to be there. I never saw a family that denied that. It was like more heads were better than one, and they felt some esteem that many people were interested. And we had a telephone. We had a telephone from behind the observation window into the therapy room. And every now and then the team would call and the therapist would say, hang on, and pick up the phone and say, yeah, okay, and hang up and say, Mom, Dad, Billy hasn't been making school, and he went to school every day last week. And I didn't ask what was going on. Billy, how were you able to do that? What happened different? Okay, so think about me as an intern, as a practicum student. Not only did I get to watch therapy happen and realize it wasn't magic, it wasn't mystical, it was just hard work, but I also got to hear really experienced therapists talk about a session, maybe say what they might have done with that same situation. It was very, very helpful. But then I got my turn. I got my turn in front of that mirror. And my practicum instructor, I love the woman, I really did, but she always would start some constructive criticism the same way. She would say, Mike, I know you've worked for the court for a long time, but I think you can be a good therapist. Really? That's how you're going to start? So she would say, look, I've watched you work, Mike, and the family is giving you little, it's like being a gold miner. And the family's giving you little nuggets of gold and you're throwing them over your shoulder because you're looking for the big strike. You're looking for the big vein of gold and you're throwing these nuggets. She said, do you understand that if you put that nugget in the palm of your hand and get the family to look at it and polish it and talk about it, it grows? No, I didn't know that, but I know it now, right? And here's a variation of that. Somebody makes success in your program, Judge, act like they're an expert consultant. Act like they know it so well they could teach others. Whoa, Cassandra, you made your level. Cassandra, would you think about teaching some of the new people that are walking in? How were you able to do that? What would you tell another program participant that was where you were at 3 weeks ago? Remember when you were in front of me 3 weeks ago and you weren't even close to making level? Cassandra, what would you have told that same person who's in that same situation that might have gone through this, right? This is a wonderful way of continuing to pat them on the back. Here, pre-session change. Here's my final one, folks, and then I'm going to take some, we're getting on to 10 minutes before the end of the hour. Pre-session change. I got to tell you this, research, the Brief Family Therapy Center in Milwaukee found this from actual research. From the time of setting up the initial appointment for therapy and the time that they walked in, almost 70% of people had made good changes. Something positive had happened. But here was the kicker. The kicker was if the person didn't ask, only 20% reported those changes spontaneously. So you've got to ask. From the time of setting up the first appointment to showing up, it was around 66%. So, okay. I know this takes a leap of faith, folks. I know it's not exactly something that you would lead with from the bench, but, or any of our treatment teams should be doing this. You know, I just want to ask, we've gone through the weekend now. What has anything happened positive? Tell me what's happened different, because if you don't ask, they don't tell you. Let me give you a good example. I had a mother. She was in our treatment court. She wasn't unemployed. She was underemployed. She wasn't directly hurting the kids. It was through omission. But really the problem that this woman had was with a nasty boyfriend. This guy was not family oriented. He was not helping her. He was taking from her. He was not helping the kids. He was taking from the kids. This guy was trouble, okay? And from one session to the next, he had left and he was not coming back. Things had radically changed for the better for her. And I wouldn't have known it, I don't think, for quite a while if I hadn't have asked, hey, Mom, has anything? Yeah. He's gone. Whoa, tell me, did you do anything to get that going? How did that, what's that say for you now? Here's an important one that you might want to ask when your defendants get in front of the bench. At least have someone on your team ask this. Okay, we have reached the end of our time. We've got about 8 or 9 minutes left, and I wanted to open it up for any questions. I'm so sorry about that break in the action. I don't know what the heck that was, but let's see. Shane, I'll bring you back in. You can type in any questions to Shane or raise your hand. How do you take questions, Shane?
So they can also unmute themselves and ask the question themselves.
Okay. Okay. Give them a minute to look around. And Shane, you know me, if they don't ask any questions, I've got about 2 or 3 more. I got 2 or 3 more of these for them. I'll load them up before they go.
Well, let's do this. How about you continue on? If you do have a question, feel free to put it in the
Okay.
chat and I will let Mike know to answer the question.
Okay, so send a chat to Shane if you have a question. In other words, here we go on 4 resistance lowering techniques, right? These are ones that motivational interviewing trains staff right out of the gate. We've already talked about this first one. Now, here's the participant statement. Ready? I don't want to go to this program. Okay, I got some problems, but I don't want to waste my time going to something twice a week that ain't going to help me. A first simple reflection to this would be, you don't want to go. You feel it'll be a waste of time because you don't think it'll help. You're not agreeing with the person and you're not condoning what they're saying. What you're doing is just trying to understand, and you're just validating their anger. You're not saying their anger is appropriate. You're just saying you're angry by how you offer your reflection. A lot of times now people would say to me, well, what good is that going to do? Look, I'm not saying that this is the answer. What I'm saying is sometimes just reflecting back allows them to feel heard. They settle down just enough so that you can get into what? You can get into more productive tracks. Here's the, yeah. Here's another good reason. You can't fight alone. Don't be the one to fight with them. Don't be the one to challenge them or tell them they're making a mountain out of a molehill or reminding them of, you may need to do that later. But at the very beginning, the first thing out of my mouth is usually a reflection, because when I do that, there's nobody to fight with. And usually they start to calm down enough to make it more productive. Amplify reflection. I take a statement like this. This doesn't always work. I don't use these in what? I don't use these in a row or in any kind of sequence. But sometimes I'll take something up to the ceiling and I'll make them drop it down. Well, I don't want to go to this program. Okay, I may have some problems, but I don't want to waste my time going to something twice a week that's not going to help. You don't need this program because you don't have any problems, Ralph. Ralph, you don't have any problems at all. Well, no, I didn't say that, Judge. I've got some problems, but okay. I usually, oh, by the way, you can't use this with sarcasm. So you don't have any problems at all, Ralph. I bet your life is just wonderful for you. No. I use it with some sincerity. You don't need this program. You don't have any problems. And usually what I get is, well, I didn't say that. I've got some, they bring it down to a more realistic level. And I don't always use this. It doesn't always work, but when it does work, it's helpful. It brings it down a notch that allows more productive talk.
Michael, we do have one question to interrupt you.
Okay, go ahead.
How do you handle personality clashes between participants and providers?
Well, one of the reasons that we are really delving into relational factors is that one of the biggest obstacles to good outcomes is the reactionary stance of staff. Staff bring in a lot of their own issues, and when they get reactive to the participant, things go sideways quickly. So I would have to say that generally watching staff and getting staff well trained in relational aspects like motivational interviewing tend to settle them down, right? say that one more time, Shane. Just give me that question one more time.
It was, how do you handle personality clashes between participants and providers?
Yeah, I would probably speak to both, and I would probably do it even-handed. Okay. But then I'd certainly want to talk to that provider, and I'd want to find out what their level is at for motivational interviewing, what their ideas are in regards to compassion and empathy. What is it that has got them stuck, right? I don't know if they're asking about this in the context of right in the courtroom in front of them with one saying one and one saying the other, or whether they're just talking about a provider who seems to be negative and anti, right? Yeah.
And a follow-up is, should we change providers when the participant says, I can't work with this person?
Well, here's what we know from research. When you start to understand, this is starting to come out. When you start to understand relational factors and what impact it has on outcomes, I know this about myself. Let's say I could condense my whole caseload into 10 people. Folks, I can pretty much get on very easily with 6 out of the gate. 6 people I'm going to be able to connect with. They're going to tell me that they like my style. They might, on a scale of 1 to 10, they might give me a 9 or 10 saying, yeah, I can really connect with Mike Clark. I want to keep working with him. A couple of them would be tough for me. A couple of them would be, I'd have to work at it. It wouldn't come right away. They wouldn't give me 10s. They'd give me 4s or 3s. And I'd have to talk to them about it. You know, I got a 3 as an evaluation. What do I need to do to connect with you better? Because I want to see you get out of this court and get healthy and get back with your kids, that because they had said that, get back with their kids. But I'm also going to tell you this. There might be 2 out of those 10 that, I'm just not going to connect with. And research says we have to figure out what pairings those are. We're not set up to do this. When I was a probation officer, if I would have said, look, I just can't connect with this person, could I trade you cases? They go, oh, we don't want your nasty case, Clark. No, it's not. There's no failure. There's only feedback. So when you have a provider saying they can't work with somebody, is it because they're reactive? Is it because they're one of those 2 out of the 10 that they're not going to be able to connect with? I'd want to go deeper with that one. Absolutely. I'd want to talk to that person. I'd want to have my court coordinator talking to that provider. Yeah.
Great. Well, thank you so very much. Unfortunately, we have run out of time. If there are additional questions, please place them in the chat and I will forward them on to Michael so he can answer them for everyone. Thank you so much, Michael, for spending the last hour with us and giving us some amazing information. As everyone, this training is now officially over. So we thank everyone for spending the last 3 days with us, and hope everyone has a fantastic weekend. Have a great day. Just write in the chat, and please do fill out those evaluations that do get sent to you so we can continue with providing trainings like this. Jeff, any closing comments?
Nope. Thank you, everybody. We had great participation, and the feedback's been very positive. Have a great weekend. Thank you, Shane. Thank you, Michael. We appreciate it.
Thanks, Judge.
Have a good day, everyone.
Bye.
Thank you.